Medical malpractice cases are probably one of the most difficult types of personal injury case that we work on. And the reason for that is that first, medicine can be quite technical and is always changing, and requires very individualized scrutiny on each case. And in addition, also requires experts in the particular field of anybody's injury. Many people are under the impression that like automobile cases, medical malpractice cases settle most of the time. That's not so. That's truly a myth. Medical malpractice cases seldom settle prior to trial, and when they do, it's only because the case has been worked up sufficiently that the defendant is convinced, the doctor and his insurance company are convinced that they're not going to be successful at trial. Doctors, unlike the rest of us, have what are called, in most cases, have what are called consent policies. They don't give up complete control of their case to the insurance company the way you and I do in an automobile case. If their malpractice carrier wants to settle a given case, most policies provide that the doctor give his or her consent to that settlement. So cases do settle, and they do go to mediation. They are frequently the result of confidentiality agreements that the insurance companies and the doctors would just soon not have these kinds of settlements out there in the public domain. And they also don't like folks who perhaps don't do as much medical malpractice work as we do know what the fair value of many of these cases are. They will sometimes suggest to a less experienced attorney that they check out the court record and go see what there are for verdicts. And there are jurisdictions around us where the verdict history is pretty dismal for plaintiffs. The fact of the matter is there are a lot of confidential settlements out there that are substantial in nature, and I believe that to be the result of insurance companies being very careful about letting the good settlements be known. One of the great institutions in our country and great philosophies that the founding fathers put in place is check and balance. It just makes sense, and it's as relevant today as it was 200 years ago. And the check and balance that we have in the medical arena and in our legal system when it comes to medical malpractice is that the fact that lawyers bring cases and are successful with those cases causes those doctors to be reported, the doctors who have committed malpractice, it causes those cases to be reported to the data bank, and it also causes hospitals to be aware of those doctors who are, for lack of a better term, repeat offenders. I think that we are all human, and that a doctor should not be denigrated for a mistake. Every person in virtually every profession has a bad day, and to expect from a medical practitioner perfection, I think, is unrealistic. But as long as we are going to ask that a doctor take care of his or her mistakes through their insurance, then those who are the victims of a doctor's bad day should be compensated. There's no point in insurance companies charging premiums and collecting insurance from doctors if we're not going to ask them to pay anything out when somebody gets hurt. So some of the studies show that doctors don't really change their habits, that they don't really practice defensive medicine, that they don't order tests because they might get sued. And I'm inclined to agree with that. I think doctors who are very careful tend to order tests, and doctors who are sloppy tend not to. But the check and balance is those doctors that are sloppy and those doctors that hurt people, they get sued. And those results of those suits are reported and known to folks who should know about that, and who will appropriately deny privileges to those doctors, and will appropriately perhaps take license proceedings against them and get them out of a business that they shouldn't be in if they're not deserving of being there. From time to time, friends or potential clients or even lawyers that don't practice in this area will ask or comment that, gee, malpractice is what's driving up the cost of my insurance. You guys are really aggravating the insurance problems in the country, and wouldn't it be better if we had more reforms and had caps and other types of so-called tort reform measures in place to prevent these perceived abuses? I invite anybody that has that outlook to just go look at the real evidence. One, I can tell you that none other than former President George Bush, when he was governor of Texas, really pulled off a minor miracle from the perspective that he got the Texas Trial Lawyers Association, representing the trial lawyers, and the Texas Medical Association, representing the doctors, to jointly undertake a comprehensive study of malpractice and the malpractice industry's, if you will, impact on the cost of healthcare delivery. That study was done about 8 or 10 years ago, perhaps a little bit more now. And the result was remarkable. It indicated that the malpractice legal system that we have, at least as it was in Texas, and it was typical of the rest of the country, had less than 0.5% impact on the cost of healthcare delivery. And I and others thought, well, that's one study, that's interesting. But that was followed shortly thereafter by the Congressional Budget Office, which is a bipartisan study group, analyzed exactly the same issue on a national basis, and remarkably they came up with exactly the same number, 0.5%. I can simply say that I know from the discussions that have been had in the Virginia legislature about whether or not Virginia should have additional tort reform, that the insurance companies tell us that huge multi-million-dollar verdicts are so rare in Virginia that they don't use them in their actuarial calculations. And further evidence that malpractice cases in Virginia aren't having much effect on insurance rates is, in this case, doctors' medical malpractice rates, is that if you look at the state of North Carolina, it has almost identical demographics to Virginia in terms of number of doctors, number of university settings, number of urban settings, country settings, and patient populations. Virginia has what might be characterized as some tort reform laws in effect that are caps on recoveries and limitations on who can testify, and other medical malpractice review panels and other devices intended to curb lawsuit abuse in this area of law. North Carolina does not. And interestingly, the same companies are writing insurance in both states, and the premiums are virtually identical. So what I take from that is that Virginia's got a good system. We are a conservative state when it comes to the award of verdicts, and I think that Virginia is frankly something of a national model in terms of how medical malpractice cases should be handled. You will not see frivolous cases being successful in Virginia. You will see serious cases with serious mistakes. If handled appropriately, the client will gain a proper settlement. And I think that's the way it should be.